Good afternoon, everyone. Welcome to our event. We'll be discussing the reputational and legal risks in connection with PPP loans. Before we start, let me just tell you that this program is intended for informational purposes only, so nothing should be considered or taken as legal advice. And any information, questions, or discussion not relate to any client matter or issue that may be considered privileged or confidential, but it'll be discussed from a very general perspective. And also, let's keep into account that there's a lot of children at home, and everyone's using bandwidth, which at times may complicate the transmission. So we appreciate your patience and understanding should any unexpected technical issue arise. As always, it is our intent to give you the information you need as seamlessly as possible. So now that we've done with that, we can move on and we can welcome our guests. We can welcome you. This webinar was actually put together fairly quickly because we think it's extremely important and we have very little time to act if needed. And what we're seeing is literally a reflection of what we are interacting with clients on a daily basis. Because initially, when the CARES Act was enacted, and the Payment Protection Program was created, the government was really pushing everyone to apply. It had a lot of exceptions to the traditional rules that are applicable to loans from the Small Business Administration or the SBA. But then, as a result of the media and other type of reputational noise, the Treasury and the SBA had to come back and provide further clarity on what they meant with the initial rules. Some people say it's a retroactive change of rules. That's not the way it's stated. It's actually just explaining what they meant and providing a safe harbor, saying, if you were wrong because I did not provide initial clarity, you still have till May 7th to return the funds from any PP loans you have received. Now, this seminar does not only address the big question of, do I need to return the funds? And if I don't, what's the risk? Because you may legitimately think that you need these funds. We are living in the middle of a very difficult situation, a pandemic where there's no clear time frame. We're still you see a lot of different, you hear a lot of different opinions as to how long this will last or the effects, short, middle, and long term. But reality is that those decisions will be made by the business people and the companies, but they need to take this in consideration. So even if you think you need it, and once Carl and Carlos go through the different elements, both on the legal side and on the reputational side, even if you decide that you're going to move forward with it or keep it, if you already received the funds, you would still need to document it properly. You would still need to be prepared because later on, you will probably be questioned. This, as usually with hindsight, it will be reviewed. So I think, it's time for the experts now. So let me introduce them. On the legal side, we have Carl Fornares. Carl Fornares is a shareholder of Greenberg Traurig, but not only is he a shareholder, he's also the co-chair of the firm's financial, regulatory, and compliance practice. And as you know, Greenberg Traurig is the biggest law firm in the United States by the number of lawyers. It was born out of Miami, where the headquarters for the Inter-American chapter of the U.S.-Mexico Chamber of Commerce is located. And additionally, Carl speaks Spanish, which makes it very helpful for a lot of our members in Mexico or who prefer Spanish as a first language. Now, Carlos Correcha Price, who also speaks Spanish, Carlos is the CEO in the United States for Llorente y Cuenca, or YIC, who is the leading communications, reputation, and public affairs consultancy firm. Initially, it was Spain, Portugal, and Latin America, but it now has a very strong presence in the United States, primarily in Miami and in New York. So I think, Carl, if you agree, I will let you because before we get into some questions, which we'll go back to, I think it'll be very helpful because some of this has moved so quickly to give a general perspective, both from the legal side and on the reputational side, as to this matter. So, Carl, if you agree, I'll let you start.
Yeah, Antonio, thank you. And I'd like to thank everyone at the Chamber for taking the time this Monday morning to dial in and watch our program. So as Antonio said, next slide, please. With a bit of the background on the PPP, and then get into some of the legal traps that really sprung over the last week or two, to everyone's surprise. As many of you remember, and this is going back about a good 5 weeks ago or so, out of the CARES Act, which was landmark legislation that was rushed Congress because of the crisis created by the pandemic. The CARES Act amended the Small Business Act to provide this so-called PPP, or Paycheck Protection Program. The congressional intent was to flood smaller businesses, generally speaking, 500 or fewer employees. There are exceptions. That's outside the scope of this presentation. But generally, smaller businesses, to flood them with cash so that they could continue to pay employees and not lay them off or furlough them for at least 2 months. Almost a bridge loan, short term, or if conditions are satisfied, it's really a grant. And so there's a concept of entities. There are the SBA affiliation rules, which tended to exclude, some of the companies controlled by private equity or VC. There's borrowing amounts in terms of limits on that. Loan forgiveness, at least 75% of the proceeds have to be used to pay employees, so for payroll costs. The other 25%, up to the other 25%, can be used for rent, for leases, other costs to be eligible for forgiveness. The CARES Act also provided more funding for the already existing economic injury disaster loan program that's under Section 7B of the SBA. Next slide, please. So the purpose of all of that, like I said, was to put cash into the hands of companies. These could also be sole proprietors or independent contractors. And like I said earlier, generally speaking, smaller businesses. There are these strict affiliation rules that if you have an operating company that is controlled by a larger company, well, you aggregate the headcount of the larger companies, and if you go over 500, then you're just not eligible. But there are exceptions depending on businesses, especially if they are businesses with fewer than 500 employees at a single location, and the accommodation, which is hotel or food service industry, businesses that operate franchises, and we're going to talk about that a bit later. And that's really, I think, what blew the lid on this. And then, of course, businesses that receive Small Business Investment Corporation assistance, which is very, very few companies that fit that. Next slide, please. So you have a class of eligible companies that, generally speaking, are going to be smaller companies, but there's no restrictions really in the Act regarding who or who should not be owning these types of companies that are eligible for the funds. Okay, and in addition, there's nothing that borrower has to prove that it could not find financing or could not obtain liquidity elsewhere. In fact, the CARES Act suspended in the Small Business Act, which again goes back to rushed legislation but it sets the playing field. It sets the size of the goal. Okay, and so this is again going back about 5 weeks ago or so when people were scrambling to apply. The goal, the size of the goal was did not say that a borrower had to prove that it lacked liquidity from other sources. And in fact, the Treasury Secretary said, relatively recently, we want every eligible small business to participate and get the resources they need. That's a very broad, sweeping statement, and eligibility really came down to the size of the borrower, or if there was an explicit exception as to the size. There was not really many other strings attached. Next slide, please. So, as Antonio was alluding, you had larger companies that were applying because they satisfied the eligibility standard. In fact, as of about a week ago, nearly 300 public companies had reported receiving PPP loans. Borrowers included 43 companies with more than 500 workers, again, because they satisfy the exceptions or the exclusions. But we also started to see that public companies began returning the funds. And as of last week, about $125 million in PPP loans were returned. Next slide, please. What was it that was happening over the last week? 2 weeks. The Treasury Department put out an FAQ number 31, and I'm going to get into it in a second, and also FAQ 39. And all of this was because of a political reputational firestorm, as Antonio alluded to at the introduction, where certain larger companies or larger names were reported to have received access to PPP loans. And it got front page attention and a lot of incredulity in the minds of people in Congress who passed this legislation. And of course, Joe Public, pounding their fist on the table, saying this is an outrage. How come the larger companies are getting funding and the smaller companies, the mom and pop family-owned businesses with maybe 10 or a dozen employees or a half a dozen employees, they're going to the bank and their banker is telling them, well, sorry, the PPP funding has run out. So that caused the Trump administration, and some of you might have heard President Trump at one of the press conferences say that this is going to come to a stop. And then, of course, next to him is Treasury Secretary Steve Mnuchin, who then starts making some public statements, and I'll go through those in a moment. And then these FAQs are published by the Treasury Department. So FAQ 31 relating to large companies with adequate sources of liquidity, and FAQ 39 where Treasury says that all loans over $2 million, in addition to other loans as appropriate, whatever that means, will be subject to review audit by the SBA and Treasury. Next slide, please. So this is all over the last week or so. And so what was it that what now notorious FAQ 31 says? So I'm actually going to read it because it says a lot. Question: do businesses owned by large companies, I bolded that, with adequate sources of liquidity, I also bolded that, to support the business's ongoing operations qualify for a PPP? Okay. The guidance doesn't define what a large company is. What in the world is a large company? Is it a company that has a handful of employees but deep liquidity? Is it a massive, companies with thousands and thousands of employees? We don't know. What is adequate sources of liquidity? What does that mean? Next slide. So that's the question that it puts out. So already the footing in terms of predictability is on a weak foundation. And then here's the answer that the Treasury comes back with. In addition to reviewing applicable affiliation rules to determine eligibility. So they're saying, if you've received PPP funding, go back and recheck the affiliation rules and make sure that you got that right when you applied, okay? And again, that's more outside the scope of this call, this presentation, but it's more on what we're about to go into. So it says, assuming you get past affiliation and that you got that right, it says all borrowers must assess their economic need for a PPP loan under the standard established by the CARES Act, which, remember that I said, is a pretty low standard, and the PPP regulations at the time of the loan application. Although CARES Act suspends the ordinary requirement that borrowers must be unable to obtain credit elsewhere, okay? So it's right here, this is what's bolded. It's sort of like saying, yeah, what Congress said kind of like doesn't matter. What we're about to say here is what matters. Borrowers must still certify in good faith that their PPP loan request is necessary. Okay, and here's where Treasury starts to define what necessary means. Specifically, before submitting an application, borrowers should review carefully the certification. Quote, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. Okay, that's what the application form said from about when it first rolled out about 5 weeks ago or so. Current economic uncertainty makes the loan request necessary. It's a very amorphous standard, okay? And then when you go back to the congressional intent, where Congress suspends the standard regarding the need to obtain credit elsewhere, okay? Well, of course, especially 5 weeks ago when the pandemic, at least in the United States, was at its worst. The news was at a very bad time. And so when you look at the phrase current economic uncertainty, there was a ton of uncertainty at the time. But then Treasury elaborates. Borrowers must make the certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity. Okay, well, that's new. Okay, that's new. You have to assess your ability to access other sources of liquidity sufficient to support operations. And then they provide an example. For example, it is unlikely that a public company, okay, now here they use a more extreme example, a public company with substantial market value and access to capital markets will be able to make the required certification in good faith, and such a company should be prepared to demonstrate to SBA upon request the basis for the certification. Okay, so this goes back to the prior slide where we talked about how several millions of dollars have already been returned by some of the larger companies, and some of you saw in the news these tended to be fast food type establishments that were returning the funds. And then notice how Treasury exculpates or takes off the hook the lenders. These are mostly banks, and there are some non-bank lenders. Lenders may rely on a borrower certification regarding the necessity of the loan request. So their Treasury's putting the banks and non-bank lenders into a safe harbor, but not the borrowers. Now look at what it says. Any borrower that applied for a PPP prior to issuance of this guidance and repays a loan in full by May 7th will be deemed by SBA to have made the required certification in good faith. Okay, so they're providing borrowers with a safe harbor that if you have any doubt, okay, and you return the money by May 7th, we're going to presume that you acted in good faith and you'll be off the hook. So that puts even more pressure on PPP borrowers to truly assess the necessity fact, especially in the light of now the goal, okay, has been broadened considerably. So it's much easier for the SBA and Treasury and even the Justice Department to look for weaknesses shoot darts or bullets into that goal. Next slide, please. And the other FAQ, Treasury noted that the SBA will, quote, review all loans in excess of $2 million. So now what they're saying is that if you're a PPP borrower and you took $2 million, automatically you're being audited. Okay, and then it says, in addition to other loans as appropriate. Okay, we interpret that as if you receive less than $2 million, there's a possibility you'll be audited. And what they're going to be looking for is to determine eligibility for borrowers in need. Okay, so it says there to ensure PPP loans are limited to eligible borrowers in need. So they're going to look at eligibility, which is in black and white, and then in need, which is very vague. Okay, so that's and they're putting all PPP borrowers on notice. If 2 million or more, for sure you're being audited. Under 2 million, you might be audited, and they're going to look at two things: eligibility and need, whatever that means. Additional guidance implementing this review procedure, meaning the audit, is going to be forthcoming. Next slide, please. So there was an interview of Treasury Secretary Mnuchin on CNBC, and he was making a lot of interesting comments that, although they're not sort of official, they're still on the record. They were made during a broadcast, and I replicated some of them here. And this was on Tuesday, April 28th, so about almost a week ago. Companies that receive more than 2 million would be audited and could face criminal liability if it turns out they were not eligible for the relief funds. I interpret that to mean in extreme examples of bad faith, where clearly the borrower had no business taking on funds, there might be criminal risk. He also says, quote, the purpose of this program was not social welfare for big business. Okay, so, well, what is big business? What does that mean? How is that different from large companies? How is that different from public companies? Then he said it was outrageous that a certain NBA basketball team, which was the Los Angeles Lakers, had taken a PPP loan and warned other companies with access to liquidity that they could face criminal liability if the loans are not returned. Quote, it's not really the fault of the borrowers. It's the borrowers who have criminal liability if I'm sorry, let me restate. It's really the fault of the borrowers. It's the borrowers who have criminal liability if they made the certification and it's not true. Okay, and now he's saying something a little bit different, which is if you stated something, it's not true, they have criminal liability. I don't think that's, I think that's a real stretch, and I think that criminal liability attaches in extreme examples, not where the facts aren't necessarily crystal clear. Next slide, please. So with that backdrop, as I mentioned earlier, where about 5 weeks ago the goal, okay, was fairly defined, somewhat narrow, then the Treasury Secretary broadened the size of the goal considerably in terms of liability and risks. So what are those risks here in the USA? First of all, there's the possibility of False Claims Act liability for borrowers, which could be civil and extreme cases criminal. And what that basically means is that if someone makes a false claim to the U.S. government, provides false information, and for example, in a loan application to receive government funding, they've made a false claim to the United States, and the United States can sue the borrower, or in extreme examples, impose criminal liability. In the case of civil liability, there is whistleblower authority where private litigants can bring their own private lawsuits using the False Claims Act, and the U.S. government pays a bounty to the plaintiff that brings the lawsuit. And then, of course, there's the risk with all of this reputational noise, as Antonio described it. There's the risk of shareholder claims against officers and directors. So it's a very difficult landscape. Next slide, please, to navigate with respect to all this uncertainty. What are some of the risk mitigation ideas in the event of an audit? Well, I think if you decide to keep the funds, there should be good governance, that there was documentation of a board or management decision, authorize the approval. There should be a resolution. There should be some discussion memorialized in minutes. There should be, we think it would be helpful for there to be financial projections that assess the operational need, getting back to that FAQ 31, so that it can be justified that layoffs might be anticipated. Also, perhaps a before and after of a summary of the financial position prior to the loan application, showing that perhaps liquidity was strong before the crisis, and then liquidity became very challenged as the crisis began to unfold. Consideration by management and board of alternate sources of capital, again going back to the board and management justification, because directors have fiduciary duties of care and loyalty to their shareholders. An analysis of existing stockholders, especially if an eligible PPP borrower is private equity or VC backed, has a highly capitalized parent, sort of a source of strength doctrine type approach that we frequently see with in the financial services arena. And then now that we've seen what has been happening over the last week, an analysis of reputational risk that can flow from the considerable unfavorable publicity if a borrowing, particularly from a named borrower, becomes public. Next slide, please. And so I think, with that last point on reputational risk, this is a good time to turn it over to Carlos Correcha Price, a U.S. CEO of Llorente y Cuenta, who's going to have his own presentation. So, Carlos, I'll turn it over to you.
Thank you so much, Carl. I appreciate it. Let me just load up my screen, and if you could please confirm that you're able to see it.
I can see you, and I see the slides.
All right. Well, look, I want to start by thanking the Chamber of Commerce and, of course, Greenberg Traurig for this terrific opportunity. I believe this is, the kind of situation where we are dealing with a very fast evolving, set of, facts before us that have, dramatically changed over the past several weeks, as both you, Carl, and Antonio alluded to. I decided to title my presentation, and I'll go through this very quickly, just because the mechanics and really the nature of how this program came about. You did such a good job explaining it. I titled the presentation Reputation 2020, and you'll see that number coming across your screen several times over. And the reason why is because one of the things that that Antonio talked about is hindsight is 2020. Obviously, if we had information that we have today, maybe we would have made some different decisions a couple of weeks ago if you were engaging already with this program. I'll flash here a quote, very famous by Warren Buffett, that it takes about 20 years to build a reputation and about 5 minutes to ruin it. If you think about that, you'll do things differently. As we think about this, several of the companies that we commonly advise have spent a significant amount of time not only servicing their consumers, providing good service, providing good products, setting up a value proposition that differentiates them in the market, and they have done a good job about communicating not only that value proposition, but also, their CSR activities and whatnot, things that, really entrench them with their audiences. Now, a program like this, obviously, given the circumstances in which we all are, could be very appealing, right? And for a number of reasons that may not necessarily be associated with a brand at the outset, may dramatically alter the way that the company is being perceived in the public eye. From our perspective, this is the sort of thing where the government, goes along the lines of, you did, what we said, but not really what we meant. And as Carl was presenting, the different, motions that this has taken over the weeks, it is very much that, right? That guidance has dramatically changed over time with FAQ 31 and then FAQ 39. So here's how we see it play out in the media, right? And then you see that, to a large degree, this whole issue has been, for a lack of a better word, litigated in the media ahead of time. You see that public companies, for example, are being named, which is unfortunate, right? Because what potentially the calculation was for a lot of these businesses was that, they were in need of the input, from a financial perspective, that they felt that they qualified. And because this program was thrown together so quickly, it wasn't clear who was supposed to benefit from it. And millions of companies ended up applying. And as the information became public, then they realized that this would have a bigger reputational impact that they probably considered or did not consider at the beginning of it. And for that reason, you have a lot of really large organizations, which include sports teams, academic institutions, large restaurant chains, asset management firms, that are now being forced, because of the way this is being litigated in the public domain through media, to return those funds so that they don't risk damaging their reputations. So that takes us to some implications that we see when thinking about PPP. Now, your participation may become public. It doesn't mean that it will, but it very well become public. And as a result, it is important that you not only think about the legal and the financial strategy here, but that you also take into account what is that potential reputational impact that Carl was alluding to on his last slide. Then guilty until proven innocent. Now, this is the sort of thing where consumers, and I'll talk a little bit about this on my next slide, are being empowered and have information, and not only the access to the information, but the ability to replicate that information in a way that wasn't possible years ago. Everyone is a journalist. And in the court of public opinion, a lot of these companies, even though there is no necessarily wrongdoing, because the guidelines were so elastic that there wasn't anything here that said they did not qualify, it just became clear as this evolved over time, that those companies will be held to higher scrutiny, by those consumers and those stakeholders who closely watch these corporations, to do the right thing. And the benefit of the doubt will not necessarily be given to those, and we have seen that play out in the media over the past week or so. The next piece talks about financial relief and how that may be a positive for the company today, but it may not be in the long run. And what I mean by that is that several companies have made the calculated decision to apply for the PP loan because it helps them with an influx of cash. But then when you do the calculation over time about what the reputational cost may be for that particular company, it may be apparent that the immediate cash influx may not necessarily make up for lost customers or lost interest in their products and services. And then the last piece that I'll talk about here is the future whiplash. Antonio talked about the time frame being very fluid. Now, while the secretary has come out and talked about how companies that have borrowed more than $2 million would automatically be audited, that audit may not actually happen in the next weeks or months. It may actually be years before a lot of companies are required to present the different proof points as to why they needed the funds. Now, with that said, this could be the situation where your company may not be named at the moment, but it may come to the fore in the next several years. And then being aware of that whiplash is tremendously important, because while you may not face a reputational impact now, you may face one in the future when your situations have dramatically changed. Now, here are 5 trends that we're seeing as a result of COVID-19. We see a need for radical transparency. Companies are being asked and demanded by the public to be radically transparent in the way that they do their communications, in the way that they talk about the state of their business. And unless that is being done, then companies are reducing reputational equity as they emerge from this crisis. The next piece is consumer awareness and empowerment. There is a tremendous movement as a result of COVID-19 where consumers are very much aware about what corporations are doing, and they're empowered to speak their mind. And there's a number of different forums where we see a lot of social activism, a lot of people just taking to the different channels and platforms to demand company action in a number of ways. And the next piece is emotional communication. We see that over the last several weeks, the communication that has come both from the consumer and also from the companies has evolved into a very emotional type of exchange, where before we headed into this crisis, a lot of the messaging was very much grounded on facts. What we feel now is that the consumer really wants to feel and understand that companies see them going through a very challenging situation and that have their best interest in mind. And then the last point on this slide is the movement from storytelling to story doing. Regardless of what the company's background has been, right? What has gotten up to this point, the amount of equity that they have built from a reputational perspective by communicating properly is no longer enough. The companies must walk the talk as it relates to funding on PPP. So storytelling to story doing is critically important, and that's why you see a lot of these companies returning those funds. Now, the last piece that I'll talk about, and with this I'll close my presentation and we'll go into Q&A, is what we see as brand evolution. We see that companies are required to have a more flexible strategy, right? Some of the things that Carl was talking about was alluded to scenario planning, right? To figuring out what is not only the financial position of the company today, but what is it going to be in the future. And then as you do that, then it's important that you understand that the mechanics of the program may change and that the strategy for how you communicate about it needs to flex with that. The second piece is anticipation as a critical business driver that goes along with the scenario planning, but anticipating some of the blowback and some of the attacks that your company may receive as a result of you participating in the program are critical here. The next piece is consumer collaboration to the degree that your company can create bonds and bridges with different consumer groups. It will be better set up to deal with any potential impact that it may have if any of these spills into the public domain through media. And then commitment with society. This is the moment for the companies, even though they're undergoing dramatic operational shifts, and some of those may result in the separation of employees, in furloughs, and a number of other different things, that the commitment with society is clear, right? And that vision and those values that the company espouses very much come to the fore. And then the last piece is that radical authenticity. What we see with the May 7th deadline is an opportunity for companies to say, you know what, we went into the program because we didn't understand the guidelines, but now that we understand it better, right, we were happy to either return the funds, pay them back, whatever characterization may be. And what's critical here is that as you look at those 7 points that Carl talked about on his last slide, in terms of if you are to retain the funds, how should you operate in the weeks and months, if not years to come? He talked about good governance. He talked about understanding your financial projections, your financial position, and then he went on to talk about reputational risk. As you weigh that reputational risk, it's important that the company understands what the narrative is across all those 7 different points, and that there needs to be a story that is both internal, that is also created properly, and backed up properly with facts and figures for the different bodies that are involved in this, including a potential audit down the road, but also for the general public, as this may become public, as we talked about a few minutes ago. So with that, I want to thank you for your time, and with that, I invite Antonio to take us home and maybe open it up for questions.
Perfect. Carlos, thank you so much. Everyone, feel free to post questions. Jorge Torres, thank you. I'll share your questions in a second. So let me start because there's so much to ask and we have little time. We have about less than 20 minutes. But one of the things, and I'll start with you, Carl, on the legal side. One of the things that I've perceived from my interactions, on in the trenches with clients is I'm relying on banks. I'm talking to the banks. They reached out to me. They said, here's the application. They're telling me what the requirements are. I am not very concerned. You already mentioned why banks and other financial institutions are within the safe harbor. So why is it perilous to follow that path of relying on banks with respect to, PPP loans?
Yeah, I think that's a good question. I think the banks, as that FAQ makes clear, they have a safe harbor. The banks here are nothing more than an intermediary. They are pushing paper. They are collecting application, having it uploaded, dispersing funds, collecting repayment. So they're just an agent of the Treasury Department here. The real party here is the Treasury Department on the PPP, not the bank. The bank is not your lawyer. The bank is not your PR person. They're not your reputation risk manager. It's important that in looking at this, if you're making a decision, look at all the facts and circumstances. Consult with legal counsel, consult with your PR people, and assume that there's going to be an audit. And so then assume those two questions, that Treasury will look very carefully at 1, eligibility, and 2, need. And the bank is not going to advise you on that. Only you can control your destiny on that, and that's by discussing it with your own internal and external experts.
Thank you. Carlos, on the reputational side, you talked about emotional communication. We actually think that this is so emotional that it triggered a very quick response from the government in the interpretation of the rules with respect to, as Carl was saying, eligibility and necessity. Thinking, because we're living in the current pandemic, a lot of companies are being forced to make, at times, difficult decisions. Do you expect similar instances where companies will face additional scrutiny by the way they behave during the pandemic? And how can reputational risk minimize legal risk?
Yeah, absolutely. Well, thanks for the question, Antonio. Look, this is not new, but it's being exacerbated by the crisis, of course, right? When you look at sort of, past record in terms of consumer activism, you see companies like McDonald's moving away from, chicken that, had been raised with antibiotics, right? For chicken nuggets. You see companies like, Walmart, making changes to its supply chain. You see companies like J&J moving away from, different, products that they use. You see Nestle moving away from palm oil as a result of backlash on oil used for Kit Kats and whatnot. So what we see is a trend that is being exacerbated by this, that companies need to think about how consumers vote with their wallets, and that to the degree that the legal strategy can be complemented and oftentimes underpinned by the communication strategy, then companies are going to be a better place to take on these sort of challenges, as they continue to move forward. The PPP is just an interesting one, right? Just because the goalpost, continues to be moved. and is really difficult, to come up with a legal strategy, that could be, easily communicated. But with that said, from a reputational perspective, we see real costs associated with the way that companies operate. So we feel that you're going to continue to receive that pressure, and that it's important that the left hand speaks to the right hand. Right? Oftentimes you get companies sending out a corporate message that resonates very well with consumers, and then from an operational perspective, then they do something else, and then that dissonance creates a friction that is not helpful. So, to answer your question, yes, I do see, this continuing to be the new normal for different companies, and that the communications of those operational decisions, is the way to proceed.
Carlos, it's interesting because you mentioned the interaction between legal and, in this case, reputation, and I think that goes also linked to what Carl was saying before about what your program should be, regardless, right? If you decide that you're going to, clearly, if you return the money before Thursday, on or before Thursday, then you're fine. You're within the safe harbor. But if not, then you'll need to develop, a whole file as to why that decision was the right decision, so that later on, with hindsight, when someone reviews it, you have a full backup for that. But it's interesting because typically people think, oh, I need to prepare documents, and some of the ideas that Carl mentioned were very interesting and necessary, including, having board meetings and discussing projections and, access to funds and, how will those funds be needed in the near future, et cetera. What typically people don't mention is, hey, email communications, which at many times may be misinterpreted. It may be like, hey, do we really need this? We have access to this line of credit. Well, yeah, but that line of credit serves a purpose that under the pandemic, maybe you think will not be enough. Then you need to prove that. But someone will go to that email and say, hey, look at what you wrote. Even the CEO didn't think you needed that. So number one, remember that everything that you write, especially if you write it internally, may be discoverable and may be reviewed by the authorities. And two, and I like the link that Carlos made to legal and reputational working together. We've worked with Llorente y Cuenca many times before. And typically the way we do that is that counsel engages Llorente y Cuenca so that they're actually servicing us while we're servicing the client, so that all these communications are subject and protected by the attorney-client privilege. So if then later on you need to justify why you made that decision, all these internal communications that Carlos may have will not necessarily be discoverable. So that's also very important to keep in mind. I'm sorry, that's a little parenthesis, but just something that came up based on our discussions. Jorge Torres, this is an interesting question. I think it's legal. Carl, I'll bring it up, and maybe between you and I, we could provide an answer. He's basically saying that there's a lot of information available to employees, and he's asking if it was the intent of the Treasury Department for the employers to use the funds to pay employees at regular compensation rates as employees contend, which I understand to really mean is the idea here that employees have additional labor rights as a result of the PPP loans, which I understand you're not a labor lawyer, but I think you can definitely talk with respect to the intent of the
the intent was to maintain current, to be eligible for forgiveness, maintain the substantially the same employment levels at substantially the same pay. If you decide to lower, materially the amount you're paying or the headcount, that's not going to get you in trouble. You'll just lose forgiveness eligibility, and you have to repay the loan. The loan is still cheap at 1% interest. So that's something that a lot of folks forget about. But I think that the key is again, were you eligible? Number one, and two, did you quote unquote need the loan under the new standard? And that's what can cause a lot of heartburn. And I think Antonio made a really good point that that if there's all of that will be discoverable in terms of intercompany internal email regarding deliberation. Should we take the money or not? do we really need the money or something like that? And I think that's something that should definitely be looked at if one is going to consider retaining the funds, particularly if the recipient is at $2 million or more.
Yeah, and I mean, I agree 100%, Carl, with what you said. Jorge, I think, the intent was not to change the labor laws. Obviously, the intent, I think, is to incentivize companies to try to keep employees and potentially not have to repay all or a portion of the loan. But if you have any labor concerns, obviously, that needs to be looked upon separately, because obviously, as a result of COVID-19, we need, employers and companies in particular need to be very careful as to what proactive methods and actions they're taking to minimize risk and basically to ensure that they wouldn't have any labor liability, whether it's just under the employment arrangement or in connection with a federal statute like OSHA, or if you're in the food business, FDA, etc. So something for further discussion. Obviously exceeds the scope of this webinar. Carlos, so this is interesting, and the idea here is that, and you mentioned heavily, the whole that this will be looked at with hindsight in the future, let's say 5 or 6 years from now. Potentially some of those loans, that a company would have applied for, and and again, assuming that they do meet the requirements of eligibility and necessity, they may still, if a company is successful at keeping certain personnel, may not have to be repaid. Again, some of this information will be public. Some of these companies may actually grow. You could see a theme where someone would link the fact that you didn't have to repay a loan to the growth of a company, and then make a stark contrast to a mom and pop shop that had to go bankrupt. So under these circumstances, if a company decides to borrow, how should they be prepared from a reputational point of view to address any concerns from the stakeholders?
Yeah, thanks for the question. Look, I mean, this is the sort of situation that requires a lot of scenario planning, right? The facts are that you will make the best decisions that you can with the information that you have at hand today. When I talked about this idea of radical transparency and authenticity that is expected from different companies, is that you're communicating what you know when you know it. I mean, I think the consumer today is way more intelligent, than we give them credit for. And I think, companies can be forgiven, for having circumstances that change over time, right? If a company experiences growth after having, gone through a traumatic event, which, this is, and it's not only, in one jurisdiction or one geography, this is, a phenomenon that we see happening globally. I think that there will be forgiveness and an understanding of why companies did what they needed to do to protect their business and their employees at the time. So my recommendation here would be to one, make the communication as straightforward as possible, right? Communicate what you can as available, right, without jeopardizing any legal or operational strategy. And then you don't have to say everything that you know, but everything that you do say has to be 100% true, right? So to the degree that you're able to communicate that transparent communication and keep an open channel of dialogue with those stakeholders, that will bode well for the company well into the future if this ever comes back.
Yeah, I think, thank you, Carlos. I think that's very helpful and something people need to keep in mind. So I think we're, 2 minutes under the hour. I don't think I received, hold on, I may have received another question. Okay, so this is the question, Carl, and it's legal, I think. The process of returning funds already received by May 7th is clear. How do you recommend the company protect itself and makes its intent to return or not receive the money clear and legally sound if it is still in the process of PPP loan approval by SBA and or by the bank it applied to? I think trying to understand what, obviously reading on the fly, but I think basically the question is, what if I have not received the loans, but I've applied for the loans and I know that, I haven't received them because it's still, in the waiting list. What do I need to do to protect myself?
Yeah, that's a really good question. So what if it's in the pipeline? As of right now, Treasury has not clarified further the notorious question number 31. And so that's the one that's created all the confusion, the fear, the worry. And so that May 7th date is still there. And I really look at it more as a May 6th date, because operationally, if you're going to communicate something, it needs to be done, as early as possible to the bank or the non-bank lender. So I think in this circumstance, my recommendation would be go through your own internal deliberation, ratify what you decided, if it is in fact to keep the funds. If the post-review judgment is that the funds are not necessary, communicate with the bank or non-bank lender and tell them to communicate to SBA. What I would probably do is a letter. Obviously the date of the letter should be on or before May 7th, and the letter addressed to the bank is communicating the intent to rescind the application, asking the bank to communicate it to SBA, and to have that letter put in the loan application file, and any questions to contact the company directly. But that the funds should not be provided. That way, I think the company is on solid footing and covered.
Thank you. So I think with that answer, Carl, anything else? It's 101. So I think, basically, unless you have anything else to add, I think we're done for the day.
No, that's it from my side, Antonio. I appreciate the opportunity. This is the kind of issue that we can talk about for hours, if not days. So I would recommend that anyone who's interested in keeping the dialogue open reaches out to either you, Antonio, Carl, or me at Llorente Cuenca. We're happy to engage in conversation and helping you think through your strategy here.
Carlos, thank you, and Antonio, thank you for moderating.
No, a pleasure. And on behalf of the U.S.-Mexico Chamber of Commerce, the Inter-American Chapter, on behalf of Greenberg Traurig and Llorente Cuenca, we thank you for attending this webinar, and we look forward to hearing from you if you have any questions, since the timeline is so tight. Take care, everyone.
Thank you all.